So hi, welcome back to my channel. So this video is actually related to Article 3 of the revised penal code. So in this video we will talk about mistake of fact. So while ignorance of the law excuses no one from the compliance therewith, ignorance of mistake of fact relieves the accused from criminal liability. So mistake of fact is a misapprehension of fact on the part of the person who caused injury to another. So he is not, however, criminally liable because he did not act with criminal intent. So an honest mistake of fact destroys the presumption of criminal intent which arises upon the commission of a felonious act. So now let us go to the requisites of mistake of fact as a defense. So number 1, that the act done would have been lawful had the facts been as the accused believed them to be. Number 2, that the intention of the accused in performing the act should be lawful. And number 3, that the mistake must be without fault or carelessness on the part of the accused. So in mistake of fact, the act done would have been lawful had the facts been as the accused believed them to be. So in other words, the act done would not constitute a felony had the facts been as the accused believed them to be. Thus, in the case of U.S. versus Peñalosa and People versus Veronilla Supra, the accused in the first case believed that she was already of age when she contracted marriage, and the accused on the second case believed that the orders of his superior officer were legal. Had they been the real facts, there would not be any felony committed. But even if they were not the real facts, since the accused acted in good faith, they acted without intent. Hence, their acts were involuntary. So in mistake of fact, the act done by the accused would have constituted, number 1, a justifying circumstance under Article 11, number 2, an absolutory cause such as that contemplated in Article 247, paragraph 2, or number 3, an involuntary act. So let us take two cases for the mistake of fact. So the first one is U.S. versus Chong, 15 Phil 488. So I will just link down below this case. So let us go directly to the ruling of this case. So Chong must be acquitted because of mistake of fact. So under this case, facts have been as Chong believed them to be. He would have been justified in killing the intruder under Article 11, paragraph 1 of the revised penal code, which requires to justify the act that there be, number 1, unlawful aggression on the part of the person killed, number 2, reasonable necessity of the means employed to prevent or repel it, and number 3, lack of sufficient provocation on the part of the person defending himself. If the intruder was really a robber forcing his way into the room of Chong, there would have been unlawful aggression on the part of the intruder. There would have been a necessity on the part of Chong to defend himself and or his home. The knife would have been a reasonable means to prevent or repel such aggression, and Chong gave no provocation at all. So under Article 11 of the revised penal code, which is justifying circumstances, there is nothing unlawful in the intention as well as in the act of the person making the defense. So also under the case of People versus Oanis, 74 Phil 257, I will also link in the description below about this case. So, under this case, so even if it were true that the victim was the notorious criminal, so the accused would not be justified in killing him while the latter was sleeping. So, in apprehending even the most notorious criminal, the law does not permit the capture to kill him. It is only when the fugitive from justice is determined to fight the officers of the law who are trying to capture him that killing him would be justified. So the mistake must be without fault or carelessness on the part of the accused. So let us distinguish the case of Chong and Oanis. So in Chong's case, there is an innocent mistake of fact without any fault or carelessness on the part of the accused, because having no time or opportunity to make any further inquiry and being pressed by circumstances to act immediately, the accused had no alternative but to take the facts as they then appeared to him, and such facts justified his act of killing the deceased. While in the Oanis case, the accused found no circumstances whatever which would press them to immediate action. So the person in the room being then asleep, the accused had ample time and opportunity to ascertain his identity without hazard to themselves, and could even effect a bloodless arrest if any reasonable effort to that end had been made, as the victim was unarmed. This indeed is the only legitimate course of action for the accused to follow, even if the victim was really balagtas, as they were instructed not to kill balagtas at sight, but to arrest and to get him dead or alive only if resistance or aggression is offered by him. Hence, the accused in the Oanis case were at fault when they shot the victim in violation of the instructions given to them. They were also careless in not verifying first the identity of the victim. So the lack of intent to kill the deceased because his intention was to kill another does not relieve the accused from criminal responsibility. So that the accused made a mistake in killing one man instead of another cannot relieve him from criminal responsibility, he having acted maliciously and willfully. So in mistake of fact, the intention of the accused in performing the act should be lawful. Thus, in error in persona or mistake in the identity of the victim, the principle of mistake of fact does not apply. So for example, A wanted to kill B by shooting him with a pistol, thinking that the person walking in dark alley was B. A shot the person. It turned out that the person killed was C, the brother of A. A had no intention to kill C. Since the act and intention of A in firing his pistol are unlawful, A cannot properly invoke the principle of mistake of fact in his defense. Then, no crime of resistance when there is a mistake of fact. So one who resists an arrest believing that the peace officer is a bandit, but who submits to the arrest immediately upon being informed by the peace officer that he is a policeman is not guilty of the crime of resistance to an agent of the authorities under Article 151 of the Revised Penal Code because of mistake of fact. So when the accused is negligent, mistake of fact is not a defense. Let's take the case of People versus the Fernando 49 Phil 75. So I will also link this case on the description box. So the defense under this case, the defense of mistake of fact is untenable when the accused is charged with a culpable felony. So in mistake of fact, what is involved is lack of intent on the part of the accused. In felonies committed through negligence, there is no intent to consider, as it is replaced by imprudent, negligence, lack of foresight, or lack of skills. So Criminal intent is necessary in felonies committed by means of dulo. So criminal intent is necessary in felonies committed by means of dulo because of the legal maxim actus non facit reum nisi mens sit rea. The act itself does not make a man guilty unless his intention were so. And actus me invito factus non est meus actus. An act done by me against my will is not my act. In reference to the case of Chong, US versus Chong. So, the distinction between general intent and specific intent. So, in felonies committed by dulos, the third element of voluntariness is a general intent, whereas in some particular felonies, proof of particular specific intent is required. Thus, in certain crimes against property, there must be the intent to gain. The intent to kill is essential in frustrated and attempted homicide. In attempted homicide, in forcible abduction, and the specific intent to lewd design must be proved. So when the accused is charged with intentional felony, absence of criminal intent is a defense. So in the absence of criminal intent, there is no liability for intentional felony. All reasonable doubt intended to demonstrate error and not crime should be indulged in for the benefit of the accused. So, if there is only error on the part of the person doing the act, he does not act with malice, and for that reason, he is not criminally liable for intentional felony. So, that ends for this video. Again, this video is related to my video under Article 3 of the Revised Penal Code. So, thank you so much for watching. Bye-bye!